inherent powers are extraordinary and are designed to prevent injustice and misuse of the legal system where no other specific legal remedy is available. These powers are not explicitly granted by statutes, but are preserved by law to ensure justice is served. Inherent powers in criminal matters. The High Court's inherent powers in criminal proceedings are recognized by Section 561A of the Code of Criminal Procedure. This provision allows the High Court to issue any necessary order to give effect to any order under the CRPC, prevent abuse of the process of any court, secure the ends of justice. Key applications in criminal cases include quashing an FIR or criminal proceedings. The High Court can quash a first information report, FIR, or subsequent criminal proceedings if they are found to be baseless, mollified, or constitute an abuse of the legal process. This is typically done in exceptional cases, especially when it appears no prima facie cognizable offense has been committed. Preventing unlawful harassment. The court can intervene to protect citizens from police high-handedness or harassment, especially when criminal proceedings are being used to settle private civil disputes. Setting aside illegal orders. An order passed by a lower court without jurisdiction or in violation of legal procedures can be set aside by the High Court under its inherent powers. Granting relief where no other remedy exists. This power is invoked when an aggrieved party has no specific procedure under the CRPC for seeking redress. Inherent powers in civil matters. In civil cases, the inherent powers of the courts, including the high courts, are preserved by Section 151 of the Code of Civil Procedure. This section allows a court to pass any order necessary for the ends of justice or to prevent abuse of the process of the court. Key applications in civil cases include correcting errors and omissions. The court can use its inherent power to correct its own orders and judgments to rectify clerical or accidental errors. Recalling fraudulent orders. An order or decree obtained through fraud or misrepresentation can be recalled or set aside by the court. Considering subsequent events. The court can take notice of and address events that have transpired since the initiation of the case to ensure a just outcome. Restoring dismissed suits. A suit dismissed due to a procedural lapse can be restored by the court under its inherent powers if it deems it necessary for justice. Constitutional and supervisory powers. Beyond their role in specific civil and criminal proceedings, high courts in Pakistan derive additional potent powers from the Constitution. Quashing FIRs under Article 199. The Supreme Court has clarified that a high court can exercise its power under Article 199 of the Constitution to judicially review and quash an FIR if it has been found to have been registered without lawful authority. Supervision of subordinate courts. Under the Constitution, each high court has the power to supervise and control all courts subordinate to it, ensuring proper administration of justice. Limitations on inherent powers. The extensive nature of inherent powers is subject to several limitations enforced by the superior courts. Used sparingly. These are extraordinary powers to be exercised with great caution and only in rare exceptional cases. No conflict with law. Inherent powers cannot be used to contravene or override express provisions of the CRPC or CPC. Not a substitute for other remedies. If a specific legal remedy or procedure exists to address a grievance, the High Court should not invoke its inherent power. Cannot re-adjudicate. Inherent powers do not allow a court to reopen issues that have already been finally decided.